Okay, joining me now is Prashant Khanna, who's a senior advocate at the Supreme Court. Many thanks to you, Mr. Khanna, for joining in. First of all, to begin with the basics, what's your assessment of what the Allahabad High Court has had to say that, grabbing of breasts or unstringing the pajamas do not amount to rape? How do you respond or assess this entire order?
Yeah, prima facie, when we read this thing, it's an unfortunate judgment because what more can amount to an attempt to rape in when the strings of the pajama has been break. And peculiarly in this case, what has happened actually, when we read the facts of the case, that this minor, we must understand that the girl was a minor, 14 years old. She was taken by these two accused person near a bridge in a culvert, that is under a bridge actually in village. These are big pipes which are used in canal system, and there in a secluded place these incidents were done. And when the witnesses approached to protect her, they were shown a country-made pistol. That means these two accused persons were armed also, and had these witnesses not reached there, then this offense of rape would have been committed. However, the High Court has taken a very lenient view and has decreased the charges from 376 to 354B. That is outraging the modesty of women. I must say that decreasing these charges of to the outraging modesty of women or try to disrobe a woman in public view is a very lenient approach from the High Court, and it is going to set a wrong precedent, especially in cases of child sexual assault against a child. The High Court has not considered at all, or has not put the victimization of a child into center, but it has taken a more lenient view towards the accused actually.
Okay. Mr. Khanna, do you think or do you agree that by passing the judgment, the court has overreached by not considering the intent of the criminal?
So court has actually not discussed about the intention of the accused in the matter, but from the circumstances or from the case that was registered by the victim's mother, was that they had taken her to a secluded place, and also they had the country made pistol. But what weighed with the court was actually that the mother of the accused number one of the accused had actually lodged a case 2 months before against the brother-in-law of the victim's mother, that is chacha ya uncle of the victim. So that weighed more instead of the allegations that were made. And in those circumstances, the court has find it reasonably unbelievable that those things may have happened. So in this slide, the court has taken a little lenient view. But what actually legally is more disturbing is that once the charge has been framed by the district court or the lower court which will try the matter, if the charges have been framed to a more lenient section, then it becomes very difficult for the district court, even if it gets the evidence that there was an attempt to rape, it cannot change the section for a higher punishment. So in that view of the matter, I must say that this has to be set aside or set right by the higher court, that is the Supreme Court.
That's a very interesting point that you've made, which is why I want to ask you, now that the court has directed that the accused should instead be tried for lesser charges under section 354 of the IPC and section 9 and 10 of the POCSO Act that amounts to aggravated sexual assault, how do you assess this order to alter charges?
But actually, in my opinion, what the accusation has been made by the victim's mother, that does amount to an attempt to rape, because as I said, they took her to a secluded place, they grabbed her breast, then they also broke her pajama, and they also had a country-made pistol. It was only because of the intervention of two people that this incident was stopped. So keeping all things aside, and the victim being a minor, the court should not have interfered, the High Court should not have interfered and let the trial court complete the trial.
Yes.
Because here what has happened that the trial has been interfered in middle. Or if the lesser charges or if the charge has been framed under lesser offense, then it becomes difficult for the trial court itself to punish them under a higher level of offense or punish them with a higher punishment. So what the trial court has framed charges in that the punishment is of 20 years or up to life imprisonment. But now High Court has framed charges under two sections which are punishable only up to 7 years of imprisonment. And moreover, I would say that since there was a child, the High Court should not have taken this approach and let the trial court decide on that.
Absolutely leaves several questions unanswered. Who protects the victims, and are the protectors also now becoming the perpetrators through orders like these? Many thanks to you, Mr. Khanna, for joining in on Plain Speak. And with that, it's a quick wrap from my end. Thank you so much for watching. Up next is The Right Stand.